Welcome to Making the Case. I'm Yodit Tewolde. One of the most fundamental principles of the American judicial system is the idea that you should be tried by a jury of your peers. But does it ever work that way for Black people? We've all heard of shocking cases where Black folk in the South have been convicted by all-white juries in cases where prosecutors have deliberately excluded Black people. And yes, that still happens. But what about cases where the racism is more subtle, where implicit bias comes into play? We'll look at how this affects jury selection and why almost every case is won or lost when the jury is sworn. Here with me to discuss is criminal defense attorney and founder and CEO of Strike for Cause Jury Consultants, Robert Swafford. Robert, thank you so much for being here tonight.
Thank you so much for having me.
This is such an important and quite frankly fascinating topic for a trial geek like myself, but especially now that courts are opening back up from the pandemic. We've got some high-profile trials coming up, like down in Georgia for the 3 white men who killed Ahmaud Arbery. So this discussion couldn't be more timely. So to start, can you just give a quick primer for our viewers about how jury selection works?
Well, the first thing that you always have to understand and make clear to people is that juries aren't selected. It's a process of elimination. And so you bring in, hopefully and supposedly a good cross-section of a community. And it could be 60, 100. I've had jury panels as large as 250. And then each side gets to get rid of a certain number of people without giving any excuse. And those are called peremptory strikes. But you have an unlimited number of strikes for cause. And so once you eliminate people either through peremptory strikes, hardships, or strikes for cause, it's the people who are left that are actually your jury.
So it's a deselection process instead of a selection process, correct?
That's correct.
And for our viewers, can you just differentiate one more time the differences between peremptory challenges and challenges for cause?
So a peremptory challenge is a challenge that the lawyers don't even have to give a reason for, unless they're engaging in something that's illegal. So you could strike someone because you didn't like their tennis shoes. Now, it wouldn't be a good idea, but you actually don't have to give a reason for your peremptory strikes. Now, the exception to that is whenever someone is using their peremptory strikes in an illegal way. For example, if you're striking someone or striking groups of people based on their race. Now, in that situation, that is illegal. A strike for cause is different. A strike for cause is there is a number of strikes for cause. And a strike for cause is one when someone says, I can't be fair, I can't follow the law, I can't follow the judge's instructions. Now, there's an unlimited number of those. And then the final reason that people get struck is hardship. Someone just says, my mother's in the hospital, or I'll be homeless if I have to stay on this jury.
Mm-hmm. All right, so now we know that a lot of Black people get excluded before the process of jury selection even begins because they aren't a part of the jury pool. And that could be for various reasons, like having a felony conviction, which would preclude them in some states, immigration status, or other methods used to discriminate against people who are poor. For example, in New York, people are selected for jury duty based on vehicle registration records at the DMV or voter registration rolls. So talk to me about the percentage of Black people excluded from jury pools.
Well, so I don't know that anyone has any real numbers about that, and I do know that what has there has been an effort to expand that. Now in Texas, it used to be that it was people who are registered to vote. If you weren't registered to vote, then you were excluded from the jury pool, and that was a double-edged sword. So it was something where someone says, well, I don't want to register to vote because I might have to lose my job because I'll be on a jury panel, and then they extended it to people who have driver's licenses. But what I think is probably a larger issue is the issue of the fact that jurors don't get paid very much. And so there are people who are having to make decisions about, well, am I going to be able to pay my rent or feed my family or serve on this jury? There are some situations where by paying for parking downtown, you would come out behind. And so one of the things that
Hmm.
can be done to try to increase jury pools is to pay people so that it makes sense for people to show up.
Now, looking at jury selection, we know that in some cases, prosecutors deliberately exclude black people, which of course is unconstitutional unless they can give a reason for the exclusion. Now, take a look at the following cheat sheet that was used in training new prosecutors in North Carolina. It should be popping up on the screen soon. It tells prosecutors basically how to come up with race neutral ways to explain why they've excluded black prospective jurors. How common do you think this sort of explicit racism is in DA offices today?
Well, my hope is that it's getting better, and it probably depends on the venue. If you're in Atlanta or in Austin or in Dallas, there are trainings explicitly for prosecutors telling them don't be making decisions based on race. And we and these are people where people are the DA is having to run for office, and that would be a real problem in rural areas. I would say that it's probably very common, but
Hmm.
the issue is that when you have a situation like that, you actually have like smoking guns. And in Dallas, Texas, there was the first African American DA who took over, found a memo that was in the DA's office by the previous DA
Craig Watkins,
saying
correct?
that's correct. Yeah.
I worked
And
for him.
Craig,
Yeah.
oh yes, and so Craig Watkins had me come up and speak to all 600 DAs, and all the people who practice in the county courts and the district courts. He explicitly brought me in to tell people don't make decisions based on race. And one of the things I
Hmm.
said is not only is it illegal, morally wrong, it really is stupid as a lawyer to make decisions based on race when you actually get an opportunity to talk to the individuals who were sitting there and be able to deal with them as individuals instead of as a demographic group.
Now, you said that in most cases, implicit bias is much more common today than explicit racism. It's also much harder to detect. Tell me what you advise defense attorneys to look for when selecting jurors to make sure they exclude jurors who might be implicitly biased against black people. Are there specific questions that they can elicit this sort of bias?
Yeah, well, so here's the thing: is that implicit bias, and just probably is helpful to just say that what the definition is. Implicit bias is that something that you don't know, you're not conscious that you have this bias, uh, and so many times what will happen is someone will come in because sort of the nature of being human is to be biased and prejudiced. There's a test called the IAT, and the IAT test allows people to test their own implicit bias. And almost everyone's really shocked whenever they come back and realize how much bias they have. And so if you ask a group of people, if you say, okay, would all the racists please raise your hands? You're not going to get
Right,
any hands because people
right,
don't think
right.
of themselves that way. And so you have to come at things
Hmm.
through angles. And so one of the things that you can do as a lawyer is you can, as a defense lawyer, is you can ask questions like, well, who here, if they were to hear testimony from a witness that's being translated, would give less credibility to translated testimony than you would from testimony in English. Now, that's not saying are you racist against Hispanic people, but it tells you something about the person if they're going to give less credibility.
Yeah.
So the answer is that you do have to come in and you have to ask questions at angles that will reflect and let people know, let you know sort of what their biases are without explicitly asking it. And I guess the answer to my question is you have to ask implicit questions for an implicit bias.
Yeah, a lot of times it requires actually pulling individuals up privately because, of course, you're talking in a group of people that you've never met before. So you're right about that. They're not going to be as honest and forthcoming. I've had friends who've been
I'll give you.
called
I'll give you.
for
I'm sorry.
jury. Okay.
Oh, I'm sorry. I was just going to follow up on what you just. And a lot of times, I just think what you said was like really on point, and that is this is the kind of issue that someone will feel more comfortable talking about in a more private setting in front of everybody else. And so one of the
Hmm.
things that people will do is they'll try to use what are called supplemental written questionnaires. And so a supplemental written questionnaire is a questionnaire the jury will fill out prior to walking into the courtroom. And we've used these before. And if you question, like, what are your feelings toward Black Lives Matter? Then that's a
Right.
question that's going to be a lot. Or have you shared on Facebook, or have you shared in social media issues or statements such as Blue Lives Matter or All Lives Matter? So if someone is sharing those types of memes on their social media, then that's something that will really give you a clue and an insight into how they look at the issue of race.
Ah, Robert, I could talk about this all day. We definitely had an issue like that, or at least in the Chauvin trial with jurors and issues after Chauvin was convicted. And I would have loved to have gotten your thoughts on that. So we're definitely going to have you back. Robert Swafford, such a pleasure having you on. Thank you.
Thank you so much for having me on.
All right.